Without objection, we'll go ahead and call the meeting to order. The Planning Zoning Committee is now in session. We're gonna start off with, minutes. Everybody have minutes? Has anybody had a chance to read the minutes? Has everybody had a chance to read the minutes? Have a motion to approve the minutes. Do we have a second? Any discussion?
Bobby Franklin and I were just talking about the second to last paragraph,
First page?
second page.
Okay.
And, we're not sure that that was completely comprehensive of, what the discussion was. But effectively, in just talking through it here, we think probably the best thing for me to do with that discussion that occurred was to approach the planning commission about site plans on multiple lots and if they wanna do anything to address it. So, that's probably what I'll do with it.
Okay, but we don't need to change minutes or anything.
No.
You're just talking about the
I'm
action
just
you're gonna take.
elaborating on what
Okay.
it was, cause I had to talk with him to kind of remind myself what it was about.
Okay, good deal.
Alright.
We met since then. and-
Yes.
Okay, gotcha. And that's what you're gonna bring to us in March, it sounds like.
Yeah.
That's what we're gonna do. Okay, we got a motion and a second. All in favor, say aye.
Aye.
Any public comment from the public? There's no public in the room, it doesn't appear, so we'll continue to march. Tom, you wanna take it and run with it on your FEMA
Yeah.
and other subjects,
Yeah.
sir?
Pass this out. I have to do this. It's a bunch of paper, I'm sorry, but, this is the way FEMA wants it. They want
Thank you.
the ordinance in its entirety amended for basically one panel's worth of changes. Did I give everybody one?
Yes, sir.
Okay. If you'll turn to, let's see if I can find the right page. If you'll turn to page 10. This is the reason for this amendment, is these panel numbers up at the top of the page. FEMA has adopted, I don't know, 10 or 11 new panels that did have a suffix D, and now they have a suffix E, meaning that they've accepted letters of map amendment that people have submitted, either the city submitted them or individuals have submitted them, and they've modified those panels to absorb those letters of map amendment, as I understand the correspondence they've given us between October and now.
Basically, we're correct, we are, correcting our resolution.
To
With
match
map
what,
numbers,
to
with the
match
map.
what FEMA is now
Right.
saying is official, because they want us to enforce against the official floodplain panels. The ordinance itself, in terms of the regulations that we enforce, are not changing to my knowledge.
Okay.
I'm also in conversation with FEMA. I appreciate you going ahead and passing this, but I'm gonna tell you about the rest of it, with
Go ahead,
FEMA.
sir. You got the floor, go ahead.
Well, I'm also in conversation with FEMA. They're a little bit, but TEMA just lost their, about 2 months ago, 3 months ago, they lost their, I forget what they call it, their FEMA liaison.
Okay.
So TEMA, that person left and went to work in another state, and they've just hired a new person. But in the course of all of that, they've gotten behind a little bit, if I understood correctly, the 8 ball on reviewing and approving amendments and things like that. So I actually had an email from them yesterday outlining how they were gonna get me a new amended ordinance and all this stuff. And I said, no, wait a minute, we got an ordinance that's amended that we amended last year at y'all's request. And the only thing that I understand we're amended is these panels. So there may still be some back and forth with FEMA, but I think this covers us for the deadline that FEMA federal has, like I'm gonna call them FEMA federal, the federal agency has given us, which is to have this adopted by April 25th. So I'm trying to get it to the March meeting, so there's no question that we got it adopted.
Do we have a motion?
Yeah, motion approved.
Do we have a second? You second? Got a motion, second, further discussion? My part of the discussion would be is if there's another change, we'll just address it when it comes down.
Yeah,
We're
I
not
mean,
worried
if
about
they
that.
come back and want us to do something different, I'll let you know about it.
Any further discussion? All in favor say aye. Aye. Opposed, nay. Okay.
Before we move on, I do wanna,
Can I ask a question, Chairman?
Yes.
Does this entire thing need to go in the packet in March?
yes.
Okay, just like it is. That's good. Me. I don't
The,
have to do anything.
That's right.
The other thing I do want to share with y'all, we're a member of the community rating system, and what that does is it gives discounts to our flood insurance holders, whether or not they're in a floodplain. Right now, or well, up until recently, we were considered, it's kind of like, it works like ISO for fire ratings, fire homeowners insurance ratings. And we were rated a 9, which gave all of our participants that had flood policies a 5% discount on their personal flood insurance policies if they had them. We are now a level 8, both in Wilson County and in Watertown. Does not include Mount Juliet city limits or Lebanon city limits. They've got their own floodplain administration. But in our case, we've been re-rated to level 8, so they should receive up to a 10% discount for their flood insurance policies. And I will tell you, one of the worst floods I ever got was not because of a natural flood. It was because of storm water coming up and going up into my basement. Before I lived in Wilson County, and my homeowner's insurance would not cover it. Flood insurance would. And if you live outside of a floodplain, it's fairly reasonably priced on an annual basis. So flood insurance is something that is probably a good thing to at least consider if you're a homeowner, regardless of whether you're in a floodplain or not. But I did want to make you aware that we did get good news that we were rated.
Does
an
the rating
8,
scale
7,
go all the way down to 1?
It
The
does,
best?
but you gotta do some serious,
What do you have to do to,
stuff
like to
that-
jump down to 7
well,
or 6?
it gets a little bit more hardcore about enforcement of flood standards, more so than we are now. Possibly elevating or even increasing some of our standards up to a level that might be viewed maybe as even, I'm not even sure they've got any 1 ratings. And I think they may have 2 in the country, but if I understand correctly, the more you do, obviously the more discounts you get for everybody, but also the more you kind of get in people's business about how their house is built and how.
Sure
they-
they do,
yeah.
sure do. All right, anything else for you, Tom?
No,
Okay,
not on that. I do have some other stuff if topics come up, so.
okay. You got,
No, I'm good.
You good?
If you got something you want to talk about?
no, I
let's talk
think Commissioner Breeze wants to bring some issues up here.
Did you bring copies of the bed and breakfast resolution that you gave me?
about it. Yeah, I did, I think.
Settle down over there.
Unless you got something else first.
No, I don't.
Okay.
Drag your chair up.
I'll bring my chair up.
Let's drag you one up, sure.
We got one up there. We got one.
Which one are you doing, the bed and breakfast or the home occupation?
Bed and breakfast. We can do home occupation too if you want. I didn't know if you wanted to talk about that.
Well,
That's up to you.
I'm hung on that stupid cord.
Okay.
We have to tear that out.
having a,
Good luck.
Yeah.
Already got the floor.
Okay, all right. So I got a phone call from a realtor recently asking me about bed and breakfast regulations and short-term rentals. So she was approached by a client who has an existing Airbnb, and he was asking her as to if he was allowed to actually sell it as and advertise it as an Airbnb. My understanding is this particular property was in existence before our bed and breakfast resolution went into effect, which would be before May 1st, 2018. But she was asking me if he would still be considered grandfathered and not fall underneath our resolution if the property transferred or sold to another person. So I looked it up. So there,
I had one. Remember Karen, we got the zoning appeals
yeah,
and kept them for first year, I think. They
Yeah.
did okay, then they got another year. Same thing.
yeah. So I've got a whole bunch of them in my district, you know, being around the lake. So, and, you know, and I've had several that have gone in front of the Board of Zoning Appeals. So I guess the question then becomes is to, you know, if they're still, if they were grandfathered before, if it sells, are they still grandfathered? And this, I guess, is a question for Mike, but, what I brought was the short-term, rental unit act information. This is from
Will-
MTOS.
Will you
I
read
will
the-
read it.
Read that
Mhm.
last,
So this is part of the legacy clause in TCA 13-7-603A. And I'm just gonna read the last sentence because the rest of it is just about, how it actually applies to short-term rentals. But it says this section also provides that the law in place at the time that the property was being used as a short-term rental unit is the law that governs the use of the short-term rental unit until the property is sold, transferred, ceases being used as a short-term rental unit for a period of 30 continuous months, or has been in violation of generally applicable local laws 3 or more separate times as provided by TCA 137604. So I came to Tom and Karen and asked them how they interpret this, because the way I read it is that, and again, I'm trying to answer the question for this real estate agent, the way I read this is that if the property is sold, they lose their legacy status per TCA and will then fall underneath our local regulation, which means they'd have to go in front of Board of Zoning Appeals. But-
That's generally the language of non-conforming use statute in Tennessee, usually until it's sold.
But that was my question as to what is our policy?
Our policy to date has been anything that predates 2018, we have not acted upon because of the state statute that said anything before 2018, I think it's May of 2018, would have been restricted from local oversight. Unless they unless they had 3 felonies associated with the property, at which point they'd let us go in and regulate it.
Right.
I guess it's a public nuisance at that point.
Yeah. Which is understandable, but, you know, the way I read this is that if the property is sold or transferred, then at that point, then they fall underneath our local regulation.
It has to come back to Bose, is what you're saying.
Right, yeah. So that way, you don't end up in a situation that you have, I mean, you're living next door to an Airbnb for, you know, your life, basically. And we should, you know, have it, everybody should have to go to BOZA, in my opinion.
Mr. County
But
Attorney.
what is your opinion?
So, I certainly agree with the sold part. I think the law's pretty clear on that. Transferred could be a sticky point, because I don't think the law
Go to the kid.
defines it. But, you know, transfer, if you sell it to me, that's a transfer. But if me and my wife own it and we get a divorce and I quit claiming my interest to her, that's a transfer, but I don't think that's gonna be the type that'll
Or an
work.
estate.
Yeah,
Like if you will it to a life estate or to an estate to your son,
Yeah.
let's say you were running a VRBO and, you willed it to, one of the things that I've actually done an amendment, actually to address an 1,000-foot distance thing that I think Lauren's also gonna wanna talk about.
I'll talk about that next.
Yeah,
I figure we talk
but-
about this first.
But I also included language in there, from our perspective, to try to forego having to enforce anything prior to 2018 regardless of what the state law says, just from the standpoint of things like what we just brought up, whether it be an inheritance type situation. Most uses and entitlements run with the land, although I realize this one, in the way we have it set up in the Board of Zoning Appeals, we do incrementally. Usually, and this is just informally, but generally they will approve it for, and the language is actually in the Board of Zoning Appeals sections, and in each residential section for bed and breakfast, it states that this will be approved for an increment of time. Well, what the board has traditionally done with that is they'll approve it for a year, and they'll make them come back in and pay and reapply. If there's been no real issues or anything, they'll approve them for maybe upwards of 3 years. If they come back again, and we don't have many that have reached this point yet, but since this was passed, but they may request to be given a longer period of time, and I think the board has maybe limited that out at 5 years or thereabouts.
I don't know that we've gotten out to 5 yet. We've
Yeah, I
been
don't
to
think so.
3
We've been to
most of
3
them, I
on
think.
most of them.
Right.
But this would require them to come back to Bozer, right? It should just require them to come back.
If it's after 2018 and you wanna
Yeah.
start a bed and breakfast, you've got to go to Boza.
Right,
Right.
right.
Now, I'm gonna point out another thing that I think is a little bit of a kerfuffle. In Lawrence District, for instance, most of the pre-existing bed and breakfast that may or may not be causing a problem have existed or many of them have existed for a number of years. If they are required to come back because they have transferred, or even to a son or daughter, or to I guess a divorcee, they would have to meet the criterion in the R1 district. The R1 district has a 2-acre requirement that I think Bobby encouraged us to put in there in the R1 district specifically. Most of those lake lots do not have 2 acres. So when they come to renew, when they come in on one they've been running for maybe 10 years, or 20 years, under the grandfather clause, because it was under one ownership, and then their child comes in to continue it, maybe the only way they can keep the second house, then they would likely not get a recommendation of approval from staff at the very least, and possibly not from the board, because it does not meet that 2-acre criterion.
I think I agree with Lauren and the folks that she got this information from on all of these requirements. The sold clearly is gonna be, an easy one. The transfer is gonna be could be a little bit more sticky. The third one about ceases being used as a short-term rental unit for a period of 30 continuous months. Of course, the law is just 6 years old, so there hadn't been a lot of that. But the burden of proof is on us to prove that it's been
And
30.
that's terribly hard to enforce.
It'll be very hard, because if they say, well, I rented out 1 week 6 months ago, it ain't 30 continuous months. And then finally, in violation of a generally applicable local law 3 or more separate times. That'll take a while. And, so the sold is where you can clamp down on this, in my opinion. The transfer, perhaps. I didn't get a chance to do an in-depth research today, but I don't think there's any case law out there on this yet, because it's just 6 years old. Actually, a little less than 6. And so I don't think there's any case law out there. I never want to be the first, but somebody's gotta be.
Well, that was my main question. Like I said, I mean, this all started because I had a real estate agent reach out to me, and she was
Good question.
asking, what is the law? So, and this is what the law says. So,
Mhm.
I mean, I'm of the opinion that we should follow the state law. So, if we have somebody who sells, then they should fall underneath our local regulation and just have to come to BOZA. I mean, I'm not saying change the BOZA process, just
Can
make
I
it that way.
treat a sale differently than I can a transfer?
I would include all of these in our, whatever,
Yeah, the state calls it.
resolution we're gonna do. Just knowing that we're probably not gonna go after the 3 out of the last 4. Maybe on a transfer, if it's clear that Lauren sold it to you, that's a transfer. But if, as I say, a husband transfers to an ex-wife, or, a son or daughter inherits it.
You got any input?
If Lauren sold to him, that'd be a sale, would it?
Yeah.
If it's sold, but there's ways to get around that, as in quitclaim deeds and
Okay.
that type of thing. So
Okay.
people will play games with you on this, if they see a
So
chance
what-
to say
imagine
that this.
that.
Quick claim deed?
So what if they happen to do a quick claim deed?
Well, a quitclaim deed should not be automatic. You can't use that to take the place of a warranty deed. But so many times, a quitclaim deed's done in a divorce situation,
Right.
or even an estate situation.
The person have to have some kind of ownership to it,
They would,
partnership or something,
yeah, they would.
a quick claim.
And there's another example, partnership dissolves and one of the partners takes the property. So I don't think you can really say that's transfer, because they just dissolved their corporation.
But if we don't have this in there, you can't do anything.
I think we need to put it all in there. I think it's a law and we gotta follow it. I'm just not anxious to be the first one to go after it.
Which
To
brings
get
me to
transferred, defined.
brings me to the next thing that I think Lauren wants to talk about, which is, and I got no problem with this, it's $1,000 distance, or $1,000.
Sure.
1,000-foot.
Yeah.
You got too much money in your budget, Tom.
Yeah.
1,000-foot distance.
Yeah.
Should,
Okay.
should we take action on this, or should we?
Do you wanna do that
further
first?
discuss?
and then
I
we'll move
don't,
to the
I'm
next
asking
part?
kind
Is what
Is that
you've
what
got
it is?
all in this resolution that you passed out?
Well, it is, but I've got it exactly opposite of what Lauren is pitching. So you may wanna, if
Go
y'all
ahead,
want
Tom.
us to enforce that in the way Lauren has laid out, you need to make a motion to do so, I suppose.
Well,
Okay.
I think we ought to empower ourselves to do that. How you enforce, how Karen enforces it as, you know,
Yeah.
but if she doesn't have the authority to enforce it if it need be, then you just into the popsicle stick, so to speak.
What does enforcement of this look like?
Well, that's the problem, is
So-
you've got several of these, some of which were some of the original impetus for this ordinance, that have been renting out Airbnb short-term rental for a long period of time. I guess the benefit of not opening up this box would be that a lot of those have quieted down and are, we don't hear from people as much anymore. If you open it back up, there are at least a few individuals that we're gonna hear from loud and early and often, about wanting to cite somebody to make them come into the Board of Zoning Appeals, go through this process. They clearly do not have 2 acres, because many of the lake lots around the lake do not have 2 acres. And, particularly in the R1 sections on the northwest part of the county. And so you're gonna get quite a few people, in all likelihood, kinda, herded into this.
Well, I think
enforcement action.
I think it quieted down because people learned that those particular properties that were causing problems were grandfathered. At which point the county couldn't do anything. And and I know several of them who have actually sold during this process. So, I mean, again, you're living next door to an Airbnb for the lifetime that you have your property. And we're never holding them accountable, and we're not able to, so again, I think it's quieting down because people have learned that there's nothing that can be done.
Yeah, but
Is this in any way tied to the next thing that's gonna come up? Or just separate?
It only
Yeah.
is because I've written something in there that's kind of going back and undoing it.
Well,
Mr.
good,
Turner,
Tom, that's the way
we
to
need
do
to
it.
address this first.
I think so, Mr. Chairman, let me
And you don't
say
have to,
one
I'm
other
putting it
thing.
in front of you so that you guys can discuss it, honestly. I'm not trying to be ugly to Lauren or anything.
The
No,
county,
I understand.
the county
I-
attorney said we need to address this separately, so.
One other way to look at this is in the state law, whether it's
That's
in our
correct.
ordinance or not.
That's
Right.
correct.
And if we don't put it in the ordinance, and if we don't enforce it when a situation arises, you could be met from a neighbor who says, you're not doing your job, I'll file a writ of mandamus with the court to force you to do it. Now, in the years I've been doing that, that's only happened twice, and both times it wasn't deserved. But it can be done, and then you gotta defend it. So I think it's wise to put it in our ordinance,
What's the
whether
pleasure of
we're
the
able
committee?
to enforce it or not.
What's the pleasure of the committee? Entertain a motion.
I'll make the motion.
Got a motion on the floor, do we have a second?
Second.
We have a second
To do what?
Yeah, to do what?
State.
to,
State
to
language.
adopt this into our resolution, state language.
All right.
Any further
I just
discussion?
use the state statute language, word for word.
Any further discussion? No further discussion heard, all in favor say aye.
Aye.
Opposed? Passes. Next item.
All right.
Well, and you,
The second half?
you may have just cured what would be wrong with this by by the action you just took, but we'll go ahead and talk about it. Go ahead with what you wanted first.
Okay, so this is the second piece, and this is the first thing I actually came to Tom with. I had a property across the street from Lakeview Elementary that was very close to the 2-acre limit. It didn't end up passing because it was like 1.95, but it was directly across the street from Lakeview Elementary, and I had a whole bunch of parents who showed up and said, how can you guarantee that we don't have a sex offender who comes and spends the week in this property right across the street from my elementary school? And the answer is you can't. So it was brought up at BOZA that we should clarify this. So what I requested was that we go back. I went back and looked at TCA, and you'll know, I mean, more than me, but I think the 1,000 feet is what the regulation is. If you're a sex offender, you're supposed to stay 1,000 feet away from a school. So I just asked Tom if we could actually add that to our resolution, that you can't have an Airbnb or short-term rental located within 1,000 feet of a school.
And that's
That was
generally
it.
the language I did add. Since we're gonna open up this, I wanted to clarify some things that we continue to get questions about. One of which is, we define all short-term rentals right now under bed and breakfast or inn. They're all defined. If you look at the definition, anything for 30 days or less by non-relatives for rental, is considered short-term rental. But we were continuing to get questions from people saying, I can't find where you've got anything on Airbnb. So what I've done is said, I've added bed and breakfast inn, and if you look at the red letters, or any other form of short-term rental to the definition. And then, in the definition, we stated that a caretaker must live on site, but in the R1, R2, A1 sections, it says on site or within 10 miles. And that's generally how we enforce that. So I added the ability for the caretaker to live within 10 miles, as long as they provide their information to dispatch and to the zoning office for contact purposes. And then down here in the red definition, I did want to clarify that it's not inclusive of RV or mobile home accommodations, as those would be defined and permitted under provisions found in the zoning resolution for RV parks, camping, or public recreation. If they're not covered under state agricultural provisions, which many times will accept those as being something we can enforce against. I just wanted people not to have the idea that they could run a VRBO using a couple campers. And then I get to the part that she had asked about. Furthermore, these facilities should not generally be located within 1,000 feet of the property corners of a property of a school that serves kindergarten through 12th grade students. The school doesn't have to serve all those. I'm trying to say, maybe you can help with the language, but any of those grades, if it serves those, they can't be within 1,000 feet of. The regulation of bed and breakfast, inns, and short-term rentals shall only apply to operations that commenced after May 1st of 2018. This is where it gets a little dicey about whether or not I need to take this language out based on what the action you just took. Any prior approvals or documented operations that existed and can be documented as operating without cessation for more than a year shall be viewed as an entitled use that runs with the property regardless of ownership change. And
That sounds like it conflicts with what we just
It
did.
conflict.
Yeah, sure.
Right, I put it in there for discussion, so I'm fine taking it out if that's what you wanna do.
Add in daycares as well.
Okay, if we add in
Yeah, 'cause
daycares,
there's-
I want a little bit of clarity on that, because there are certain daycares that we do not know exist. But if they're under a
Well, that
certain,
becomes another issue with the
if they're
zoning.
under a certain, if they're under a
There's
certain,
certain Airbnbs
uh,
we
what number is it?
Yeah.
I think it
Where
might
did I
be
send?
I think it's eight.
It's
eight.
If it's
Because you
under,
can run a daycare out of
Yeah.
your
if
home.
if you're running daycare out of your home, I don't, and we don't even know about it from a zoning perspective, how can we enforce against, if somebody just comes up and says, I'm running a daycare, I mean, pretty much anybody that wants to do this, somebody can come up and say, I'm gonna run a daycare, and I don't think that's necessarily fair to the applicants.
What's the threshold for having to get a license to operate a daycare? Isn't it 8 students or
I think it's eight.
4 babies or 8 babies, whatever?
It's eight.
Okay. So if
Pretty sure it's under.
Yeah, so under
Yeah,
the state regulations, if it's a state regulated daycare, then it
Yeah,
needs to be in.
just worded that way.
Because it's gonna be, that's the law,
Okay.
that's the law for sex offenders as far as schools.
Or a state regulated daycare.
Yeah.
That was the only thing I wanted to clarify there.
And I think I'm looking because I want to say that I actually did I send it to you or did I hand you
What?
the regulation about sex offenders? Because I had originally pulled out the actual. I mean, like I just copied TCA and it included daycares and a couple of other things. So I just copied and pasted that. Did I give
I
that
don't,
to you
Should I
or?
put above 8
I'm
students
trying to
in
find the
parentheses?
email that I sent.
Do what?
Should I put above 8 students in parentheses?
you sent it to me by email?
Because that
Well, that's
may
what I was
change.
looking to say. I thought that I did, but I'm not finding it in my
Okay.
sent
You don't
box.
get
So
no emails.
So what
I know.
action, Mr.
yeah.
Attorney, do we need to take on this?
Yeah.
He's gonna add the daycare, state
Yeah.
licensed daycare, and
There's in TCA. There's a list.
So I
Yeah, it
struck,
needs to go
So-
on.
I struck
Yeah,
the,
so
I
it's-
struck the language that was.
Exactly. That was mine.
let's let Tom say what he
I
struck
struck
here.
the language that was opposite of the action you just took to adopt the state regulations. I'm going to add the state regulations to the ordinance that I've written up here. And then on the 1,000 feet thing with the sex offenders, furthermore, these facilities should not generally be located within 1,000 feet of the property corners of a property that operates as a school that's serving kindergarten through 12th grade students or state regulated daycares. And should I say state regulated school?
No.
Okay.
Can you
No,
strike
because you've
generally?
got some of them down there on the church property in Mount Judy's, not
Should you
state
s-
regulated.
Okay.
Amen.
Should you strike generally?
Okay, I'll strike generally.
Does everybody understand what the
And add-
modifications to the,
I guess I should say allegedly.
But
Add state,
regulated daycare?
State regulated daycare.
no, the previous
they
action.
don't have a site plan yet.
Playground is one.
Gotcha. Yeah,
What
there's
we
a
did
whole
about
list.
adding that
Yeah.
statute in?
And that's what I didn't.
Yeah, we
initially
gotta
see
include
that
those
was
four.
State
that.
statutory.
Yeah.
Is it 1,000 feet? You can't say
I'll
here.
put on the email.
Okay, does everybody on the committee understand the changes we're talking here?
And everything else
Yes, sir.
is just adding in or other forms of short-term rental for the most part.
Okay.
In each section, so that it's more clear to people that are trying to run VRBO or Airbnb and they call.
But,
So you're
Mr. County Attorney,
satisfied? You're satisfied?
Yeah.
Mr. County Attorney, would you clarify one more time what we're doing so everybody understands? 'Cause
We are.
The reason I'm saying that, we're on camera here and I wanna make sure that we have a
Yeah.
record of what we're
You know,
doing.
we've got certain things already in the zoning law that the Board of Zoning Appeals is called on to interpret, like the 2 acre requirement, the 10 mile caretaker live within 10 miles. We're including stuff that is required by the state now, for the Airbnb about to transferred or sold or whatever. And then also making sure that, an Airbnb is not within 1,000 feet of a school or a state regulated daycare.
Well, there's more stuff in that. We need to probably look at the TCA and almost list everything, 'cause it labels playgrounds and other things too. So we need to actually go into the if we're gonna go by the state regulations, then we've gotta pretty much copy everything that is within that
But
TCA.
what we're keeping down is the Airbnb.
Right.
So if they're within 1,000 feet of, you're saying any of these other things.
If we're going with schools and, the
Yeah.
daycares, then we're probably gonna have to go with playgrounds and some of
Could,
these other
could you,
things. that
could
we-
you not
Makes
say?
sense.
It's basically anything
as
dealing with
listed-
children.
As
Yeah.
listed in the statute, and quote the statute.
Yeah, we can,
I think that's what I
Which is
proposed originally.
4039-211, also 4039-202.
You could include a park, public park.
Parks, playgrounds, it's got a list of several different things.
I personally big on empowering yourself to enforce things, whether you do or not, that's your option.
Yeah, but
Some-
if we don't enforce something we're empowered to do, we can get in trouble that way
I
too.
understand that, Tom, that's where you're making that big money, so you know whether to do it or not.
I'm also interested in trying to keep it simple, stupid.
I understand.
And
We're-
not
we're
calling
trying
you
to-
stupid, I'm.
Yeah.
what he's saying is
Just
he's interested, and I am too, in making sure Wilson County's not on the defendant line.
I
When
understand
somebody
that too.
sues us,
I
But you
second
can't get on
that.
the defendant line without,
you know, without doing something.
do we hear a motion on the latter thing that the county attorney just clarified for us?
Well, since he did, I'll make the motion.
Thank you very much. We have a motion, do we have a second?
I'll second it.
We have a motion, do we have a second? Further
This-
discussion?
This will go to planning first, and do you want it to come back through here, or you want it to go straight
Sure.
from planning to the county
She
commission?
needs to drive back to Lebanon one more time.
All right, I'll take it to planning and then bring it back.
We'll have a meeting just for commission sometime and review it. Planning may have some input to it. So we'll do
We're back
6:30.
in 3 weeks.
Okay, any further discussion? All in favor, say aye.
And
Pass.
Tom, this
What-
will have to have a public hearing on it before it goes to commission.
That-
So we'll
that-
probably not get there in March.
No.
It'll
It can.
it'll have to have a public hearing at planning and public hearing at county commission.
It'll be, the 15th is planning and the 18th is
No,
commission.
15th, I believe planning is
Oh,
kind of
oh, you're right,
22nd.
you're right, because Thursday is.
Third
the 21st.
Thursday is after.
That's right.
Yeah,
True,
so
true.
it'll be April before you
Okay,
gets to you.
that's fine.
Good, the Easter Bunny done been here.
Other business? Other business come before the committee? Seeing there's no further business, we have another motion.
Motion to adjourn.
Motion to adjourn. We stand adjourned.